Today we're going to talk about personal representatives, what they do, and how you find one. My name is Gregory Singleton. I am an estate planning and probate attorney in Minneapolis, Minnesota. I work for Signature Law, which serves the Twin Cities and Greater Minnesota alike. So, what is a personal representative? Well, in some jurisdictions, they may be called an administrator or an executor, or if you want to get fancy, an administratrix or an executrix for women. But here in Minnesota, we call them personal representatives. They're the person who takes care of the estate after someone dies. Who gets to be a personal representative, I guess, is the first question. Generally, if there's a will, it's the person designated in the will. There's usually at least one or two people designated as the personal representative and the successor personal representative if the first person can't do it. If there is no will, then it falls to the surviving spouse who's receiving something in the will. Then it goes to another devisee. It goes to the surviving spouse that's not in the will. Other heirs. After that, after 45 days, any creditor can be a personal representative. And after 90 days, any conservator can be a personal representative. Now, there's a lot of responsibility that's taken upon by a personal representative. We'll just call them a PR from here on out. They are a fiduciary. They are a fiduciary to the estate and to the beneficiaries of the estate, which means they have a higher duty to take care of things. And they can get in trouble if they don't act in good faith in doing their duties. There is some limitation on personal liability. That's for contract with the estate and for various torts that are related to the estate. But in general, they are subject to various fiduciary duties. The PR can be required to have a bond. That's often required by the court. Now, it can be waived by a will or by all the beneficiaries or devisees to the will. They can all sign a waiver and then waive the bond. But otherwise, a bond is generally required in Minnesota. What you're trying to do as a personal representative, or at least one of the first things you need to do, is get the letters. Now, if there's a will, they're called the letters testamentary, and if there's not a will, it's called the letters of administration. And essentially what these do is gives the personal representative authority to manage the estate. Now, that doesn't happen until some days into the process of probate, but up until that point, the personal representative may be doing some things to secure the estate. So the authority for the letters actually relates back to whatever was done before the letters were authorized. So if something needs to be done before the letters are issued, then that can be done by the presumptive PR. Now, there are three basic duties of the PR. First is inventorying the estate. Second is managing and protecting the estate. And third is distributing the estate. Now, inventorying is exactly what you would think it is. It's gathering all the assets, putting together an accounting of them, maybe doing an appraisal of various things, and getting ready to distribute them to the appropriate devisees, spouses, heirs, creditors, etc. Managing and protecting the estate is a little bit more interesting. First of all, they, of course, collect and hold on to the estate. But then they can do things like vote on the stock, sell property, maintain the property and buildings that are owned by the estate. They can perform contracts. They can even litigate. For example, if a contract is not being performed by someone that is a party with the estate, they can sue to have that contract performed. Or if there's a minority shareholder disagreement, the estate can actually sue, or the PR can actually sue on behalf of the estate to protect those minority shareholder rights. Distribution of the estate, it essentially follows a statutory scheme that we have in Minnesota. It may be different in various jurisdictions, but essentially this is what it is. First, people that are paid are the ones that are doing administrative costs, and these will be attorney fees and personal representative costs. After that, funeral expenses get paid. Then it gets kind of interesting. Third is taxes and federal debts. Then fourth is the medical, hospital, and nursing home expenses for the last illness, and that's the illness that led to the death of the individual. Fifth is medical, hospital, and nursing home expenses for the last year predating death. Then it goes state taxes and debts, which include creditors. And finally, finally, all other claims, such as beneficiaries, devisees, and heirs, are paid out of the estate. Now, that's a lot of work. That is a lot of work for someone to take on. But luckily, they don't have to do it alone. There can be co-personal representatives. While I advise people that are doing like a healthcare directive to not have co-agents, having co-personal representatives is not a bad idea. They can delegate and distribute who does what. Also, they can hire the PR can hire attorneys, CPAs, appraisers, and other professionals to help administer the estate. Now, with all that responsibility does come some compensation. Now, it's done differently from state to state and dramatically differently from state to state. I'll give you an example here. We'll first show California. To run through it real quickly, the first $100,000 of the estate, the PR gets, or I guess their executor in California, they get paid 4% on the first $100,000. On the next $100,000, they get 3%. On the next $800,000, they get 2%. On the next $9 million of the estate, they get 1%. On the next $15 million, they get 0.5%. And on $25 million and above, they get what is just generally a reasonable amount as determined by the court. So, for example, if an estate is $3 million, for the first $100,000, the individual will get $4,000. On the next $100,000, they get $3,000. On the next $800,000, they get $16,000. Math. And on the next $9 million, they'd get $20,000. And if you add all that up, it comes together as $43,000 is what the PR or executor would be paid for administering the estate. That's a lot of money. That comes right out of the money that would go to the beneficiaries and heirs, and it in fact is paid first. This is the reason why people in California and other states like New York and Florida that have similar laws try to avoid probate, because it is exorbitantly expensive. Now, Minnesota does allow for compensation for personal representatives. However, all their PR is entitled to is what is called a reasonable compensation for services, and that'll be determined by the court. In many cases, in my experience, a lot of people just waive the reasonable fee that personal representatives are allowed. At least in Minnesota they do. Oftentimes when people are drafting a will, what they'll do is say, instead of compensation, here's $3,000 or $4,000 for acting as my personal representative. They give a gift in the will and have that be the compensation for the personal representative. And it seems to work out pretty well. The final thing that a personal representative needs to do is close the estate, and you do this through a closing statement. And that includes, at this point, you've paid everyone out, you've done an inventory, you've distributed all the funds, et cetera, et cetera, et cetera, and you're done. Now, even though you've put in the closing statements, I guess you're not quite done. The duties of a personal representative continue for 1 year after the closing of the estate, and that includes the fiduciary duties and responsibilities. So it's a real undertaking to be a personal representative, no matter what state you're doing it in. To pick a personal representative, they need to be someone that's 18 years old. By law, they just have to be an age of the majority. You should probably find someone that's trustworthy, because no one's going to be looking over their shoulder. And if you have someone that's untrustworthy, it may end up in litigation. But when the other beneficiaries and heirs don't believe what the personal representative is doing. You need to have someone that's willing to do it. You can't just assign someone without telling them. I guess you don't have to tell them, but they do have to be willing to be the PR. And finally, this is a big one, they have to be able. They have to, in two respects. One is the cognitive ability, which is basically a lot of organization and being patient. That's what they really have to do. And also capacity. If it's a single mom that's working a job and has 5 kids, they may not have the time to be a personal representative of an estate. So find someone that is trustworthy, willing, able, and over the age of 18. That's kind of the ballpark of things that go along with personal representatives. I hope you enjoyed today's video. If you did, please hit that like and subscribe button below. If you have any questions, feel free to answer or ask them. You can answer them too, but feel free to ask them in the comments below and I'll try to get to them. Otherwise, until next time, this is Gregory Singleton with Signature Law.